All rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Our next case is Charles Schwab. Good morning. Our next case is Charles Schwab versus Marilley, and we will hear from the appellant.
Thank you, Your Honor. My name is David Redding for the appellant, Peter Marilley. I'll reserve 5 minutes for rebuttal. The sole issue presented to the court is whether or not the trial court erred in denying Mr. Marilley's motion to stay the action in the trial court and to enforce an arbitration agreement to which Mr. Marilley was a party. The action arises from a series of transactions with Schwab, then TD Ameritrade, and his daughter, Lauren, who's the other appellee, that date back to 2005 with the original account that was established under the Uniform Transfer to Minors Act, when obviously Lauren was a minor. That account had a series of deposits and withdrawals for various reasons. In 2016, just before Lauren became 21 years old, she and Peter executed a document converting that UTMA account to a joint account in the name of Peter and Lauren together. About a year later, Peter asked TD Ameritrade to restrict that account so that no trades could be made unless both he and Lauren had approved of those trades. He asked for that in writing, was assured in writing that that restriction would be in place and would not be removed unless the parties agreed to do so in writing. And this restriction did remain in place for several years until the end of 2022, after Schwab had purchased TD Ameritrade and made a business decision to remove all such restrictions, and did so with respect to what is now the joint account, but did not notify Peter of that. Sent the notice to an address that where only Lauren lived. She had managed to change the specifications in the account, so he didn't receive notice. The address had changed. So after that, she moved the money from the joint account to an individual account that she had in her own name, depriving Peter of access to it. When he discovered that, he notified then Schwab of what had happened, and Schwab froze the assets in the individual account, leading Mr. Marilley to initiate the arbitration pursuant to an arbitration provision in the client agreement under the rules of FINRA. And after that, Schwab filed an interpleader action in Superior Court in Mecklenburg County, which was removed to business court, at which time Mr. Marilley made his motion to enforce the arbitration agreement. The trial court step through the two-step analysis that is necessary to determine whether or not to enforce an arbitration provision. First, finding that there was a valid agreement between the parties, something that Schwab did not dispute. Lauren disputed it, but the trial court took notice that she did not provide any reasons why she shouldn't be held to it, so found that it did apply. But when moved to the second step, the trial court found that this particular dispute was not within the scope of the arbitration agreement, primarily because she read, this is the judge, that read the arbitration agreement only to apply to disputes between an individual account holder and Schwab, but never between co-individual account owners. The trial court relied heavily on words in the arbitration agreement, the terms that were defined as I and you, I being an account holder, you being Schwab, and found that there could be I to you arbitrations, and Lauren would have been subject to those as well, but never I to I. In other words, not Peter against Lauren. And found that that was not explicitly found in the arbitration agreement. However, it doesn't explicitly say otherwise. In other words, the arbitration agreement itself doesn't say there are no I to I arbitrations, that you're restricted to that. So our contention is that that's an overly restrictive reading of this, and there's a couple of glaring reasons for that. Number one, Lauren, if she had claims against TD Ameritrade or Schwab, she would have had to bring them in an arbitration. Peter already has an arbitration. If you read the agreement the way that the trial court did, you would have to say those two arbitrations would have to proceed separately. They couldn't be together, which obviously would make no sense. Which is why incorporated into the arbitration agreement are the FINRA rules. So those are specifically incorporated. And those FINRA rules provide for the joinder of claims, just like this. Specifically, Rule 12313 allows for multiple respondents in the same arbitration, where there's common questions of law and fact that arise under the same series of transactions. Well, that's exactly what's happened here. So the common questions of law and fact are this. Number one, did Schwab have the authority in the first place to restrict the trading of the account? Number two, having done so, did Schwab have the authority to lift the restrictions and not advise Mr. Marilley of those, such that Lauren was able to transfer funds out of the joint account into her individual account without Mr. Marilley being able to control that? Those common questions of law and fact arise out of the same transactions and are so intertwined that they can't really be separated, which is why appellant contends that it was in fact the intent of the drafters of the arbitration agreement that you could join claims. Otherwise, it really doesn't make much sense. Also, under Rule 12303 of the FINRA rules, it allows for cross claims, third-party claims, and counterclaims. So that would also make no sense if you could only have an I to you arbitration and never an I to I arbitration. Essentially, it's the same as the rules of civil procedure, that any claims that are related to that need to be decided or can be decided together are allowed to be decided together. There's no difference really between the FINRA rules and rules of civil procedure for that purpose. That's one reason why the trial court's interpretation of the arbitration provision is overly narrow. Trial court also said that the ownership of the restrained assets, these are the assets that are now in the individual account, is not controlled by the client agreement itself. That was another grounds that the trial court provided for not allowing or not compelling Lauren to arbitrate. And that overlooks a specific term in the client agreement itself, specifically 4D of the arbitration agreement, which refers to multiple owners. If there is more than one account owner, which is the case here, there was one more account owner, there still is, but Lauren and Peter are the joint account, that the joint account will be held jointly and with rights of survivorship unless I, being Peter or Lauren, notify you of a different form of ownership and provide such documentation. So it's not accurate to say that the client agreement does not encompass joint ownership of an account and specify that it will be treated as one with a right or survivorship in it unless notified otherwise, which did not happen in this case. There's no point at which time Peter notified Schwab that it was no longer a joint account, or that he didn't intend to have right of survivorship in it. So the client agreement does actually encompass joint accounts, which is we're at the heart of this. The arbitration provision itself is very broad. It applies to any controversy arising out of or relating to, any controversy arising out of or relating to the client agreement itself, the relationship between the parties, and any service provided. Here, the services provided that are at issue are the holding of the joint account in the first place by Schwab, restricting the joint account, holding the individual account that Lauren opened on her own, and allowing the transfer to the individual account, and now freezing the assets in the individual account such that Lauren doesn't have access to them either. Those are all services that have been provided by Schwab. So the controversy itself applies to all three of those things. It was governed by all three of those things. Those are very broad categories that are applicable. So this controversy should be covered by that arbitration provision.
Do you see any limiting principle to your interpretation of our relationship? I mean, I understand your argument that it's broad, but it seems to me it could have some very significant domino effects under the FAA of how much interpersonal drama is getting litigated and settled in the context of these kinds of situations.
Well, if Your Honor means interpersonal drama between, said Peter and Lauren, obviously, because the record does reflect that there was tension between them. But I would contend that that has nothing to do with the plain language of the arbitration agreement and whether or not a court should enforce it. So the limiting principle between our relationship should be that if it is a controversy that's related to the brokerage relationship between Peter or Lauren or both, then yeah, it would fall under that provision. If this was something completely unrelated to Schwab, then yeah, if Schwab's not in it, then obviously. And this is something the trial court pointed to it and said that neither Peter nor Lauren are brokers and thus not subject to FINRA. Well, that's true, but all it requires is one broker to anchor the case, the one broker here being Schwab. So the relationship is actually three ways: Peter, Schwab, Lauren. That's the relationship that's being referred to. I would agree that Peter could not bring an arbitration claim before FINRA solely against Lauren. But that's not the case here. It's against Schwab for what Schwab did and involves things that Lauren did. The initial claim was only for a declaratory action in the arbitration. It was only to declare that the joint account was what it was, that was a joint account between Peter and Lauren, and that the restrictions should still apply. And that was the initial claim. And there's really no way to do that unless the panel itself evaluates whether or not who owned the actual joint account, which is the thing that the court reserved for the court itself. So the ultimate ruling by the court is, yes, Peter, you can go arbitrate with Schwab whether or not Schwab was negligent or in breach of contract for allowing the transfer of the funds from the joint account to the individual account. You can do that. So that has not been stayed. However, per the trial court, the issue of the ownership of the joint account is going to remain with the court. Now, the big problem with that is it's a risk of inconsistent verdicts, but also as a practical matter, how it could be done. So breach of contract and negligence both require establishing a breach, some sort of duty. If Peter has no ownership interest in the joint account, then there's no duty that's been breached by Schwab. They've essentially allowed the transfer of funds that are owned solely by Lauren. So the arbitration panel has to make some sort of determination as to whether or not Peter has an interest in that joint account. That really has to happen because breach is an element of both claims. Arguably, it's not a breach to allow the transfer of assets that belong solely to Lauren, but what if the panel awards Peter damages? Says, yeah, it was negligence or breach of contract for Schwab to have allowed that transfer. And then you're entitled to damages. The damages would be half the interest in the joint account. Well, that implicit in that determination would be that Peter was in fact a joint owner. Simultaneously, if the trial court says, no, Peter's not a joint owner, those funds are solely the property of Lauren, you can't reconcile those two outcomes. The panel has said, yeah, you're entitled to damages because you shouldn't have done it. And the court says, but they were never yours in the first place. Those can't be reconciled. It could also work the other way. The panel could find no negligence or breach of contract by Schwab, which means either Peter didn't have an interest in the funds in the first place, or Schwab was entitled to transfer them anyway. Simultaneously, the court could find that Peter is in fact a joint owner. But now the funds are with Lauren, and there's really nothing the panel can do about that.
So what weight should we give to the potential practical consequences that you're talking about? I mean, should they be part of our determination, or should we simply be construing the text of the arbitration provision?
We contend you should give the practical consequences the weight they deserve. They should consider them, because Peter bargained for the right to arbitrate. And the practical consequences of the judge's ruling is that he loses that right. Although the court has allowed him to arbitrate negligence and breach of contract, he's not allowed to arbitrate it fully. The actual ruling says you can arbitrate those claims, but not make a determination of ownership of the assets. Well, that means that the arbitration panel really has no power to fully rule, and Peter has been denied a substantial right to arbitrate those claims. And the way to get to that determination is through the practical consequences of what happened. So that's why the court has to consider those. Otherwise, it seems on its face to be a just result to say, well, we'll determine ownership of the assets here in court and allow you to arbitrate the negligence with the panel. But as a practical matter, it simply doesn't work, because you could come out with these inconsistent and unreconcilable outcomes in two different directions. So, to summarize, this is not an intra-family dispute as both Schwab and Lauren would characterize it. It's not an intra-family dispute that has no business in front of an arbitration panel. It's actually a dispute with Schwab, which is governed by the arbitration provision, that invokes Peter's family. They're involved. There's drama there. That is true. But the primary wrongdoing from my client's perspective is the actions taken by Schwab. Schwab really had a great hand in creating the dilemma that we're in now. Whether or not Schwab had the right to restrict the assets in the first place so that they couldn't be traded without joint consent, that started the problem, but then lifting it without any authority to do so, that completed the circle. Schwab should not be able to avoid liability for that by interpleading the whole thing into court and saying, look, this is just an intra-family squabble. We have no dog in this fight. That's not true. Either Schwab is allowed to place restrictions on accounts like this, or they're not. Either Schwab is allowed to lift those restrictions unilaterally and not notify all joint account holders, or they're not. And that needs to be adjudicated. Schwab's role in this case has to have a consequence one way or the other. And the only way to do that is through arbitration, because in the court, they're standing back, they have no real exposure. So it would not be in the best interest of any of the parties really to allow that to happen. Certainly it wouldn't be in the interest of future account holders who are trying to get their rights, trying to enforce their rights with brokerage houses like Schwab. If Schwab could simply avoid it by putting things, interpleading claims where there happen to be two or more people involved. So for those reasons, we would ask this court to overturn the trial court and allow this, or have this case arbitrated by the panel rather than being split into two jurisdictions as it is now. Subject to your questions, I'll just reserve the rest of my time.
Thank you, counsel. We'll hear from the appellee.
May it please the court, I'm Eric Spengler on behalf of the appellee, Lauren Marilley. Lauren is a 29-year-old nurse practitioner who lives in Charlotte. She is the owner of an individual brokerage account that is the subject of this dispute, and that brokerage account is maintained by Schwab in the state of North Carolina. Lauren has been estranged from her father for well over a decade. She has not been to the state of Florida where her father lives during that period of time, and she has no other connection whatsoever to the state of Florida. Notwithstanding those facts, Lauren's father filed an arbitration claim against Lauren in the state of Florida, seeking $147,361 from Lauren, money that she was irrevocably gifted by her paternal grandfather. There is no dispute of material facts. Peter, the father, contributed none of those funds. They all came from the grandfather. But curiously, the grandfather is not a named party to this case, although Peter purports to be seeking a recovery on his behalf. The grandfather is now 95 years old and subject to a guardian in the state of Florida. I don't want to dwell on the merits of the case because that's not really before the court, but they are before the court to the limited extent that the issues that we're talking about and the causes of action asserted by Lauren as the court determines whether they're subject to arbitration. And so I want to call the court's attention to her claim for constructive fraud, which is brought in the cross claim. And that claim relates to conduct by Peter that predates the formation of the customer agreement and relates to the formation of that agreement. As my friend opposing counsel noted and disclosed to the court, the client agreement was signed by Peter and Lauren approximately 1 week before she turned the age of 21. And that's a critical fact in this case because up until the point that Lauren turned the age of 21, Peter was a custodian of a UTMA account and had a fiduciary obligation at the time she turned 21 to deliver all of the assets in that account to her. And rather than comply with his obligations, Lauren alleges that he instead had her sign a joint account agreement, the conversion application, and now, based only on that application, is claiming that he has a right to funds that are in that joint account. If that's the case, which Lauren denies, she has alleged that Peter has committed constructive fraud. He had a fiduciary obligation as custodian to deliver assets to Lauren when she turned 21, and in breach of those duties, he had her convert the UTMA account to a joint account, only to later claim a personal benefit from the conversion. So no matter how you slice it from Lauren's perspective, these assets are hers, whether because they never were Peter's to begin with, or because he breached his fiduciary duty as custodian of those funds in having her execute the conversion application. And Peter's arguing that even Lauren's cross-claim for constructive fraud, which again relates to the formation of the conversion application and predates the customer agreement, that too is subject to arbitration, and that simply cannot be the case. I'd like to address a few points that were raised by Schwab and Peter in their briefs that were filed after my client's response brief. First, we agree with Schwab that this matter is an intrafamily dispute that has no business being before FINRA arbitration in Florida. And specifically, we agree with the assertion Schwab made in oral arguments at the trial court that Peter cannot improperly leverage the customer agreement to use the FINRA forum against his daughter. There is one slight factual issue I wanted to correct with Schwab's brief that was filed slightly after Lauren's brief with this court. In that brief at page 8, it recounts in Peter's statement of claim in arbitration that Peter alleges he provided all of the funding that's at issue here. And that's simply incorrect based on the amended statement of claim that Peter filed later in time. That's found in the record at page 66. And after I disclosed to opposing counsel, not Mr. Redding, but a prior attorney, that in fact Peter had contributed none of those funds, in the amended statement of claim, they removed that allegation altogether. And there's no dispute of material fact that all of the funds at issue that are restrained by Schwab were irrevocably gifted to Lauren originally by her grandfather and not by Peter. I also want to address the allegation in the reply brief by Peter that Lauren has engaged in improper forum shopping by demanding that her claim be heard in state court in the state of North Carolina. There are 3 parties before the court today, and my client's the only client who has not filed an action anywhere. Peter first filed an action in FINRA arbitration in Florida. Schwab filed an interpleader action in Mecklenburg County Court. My client has not chosen any forum. She does not seek this fight. She does not have any interest in pursuing or litigating claims against her father, but she's here and she has a right to have those claims heard by a jury of her peers. Next, I want to move to the standard that the court should apply to evaluating the arbitration agreement at issue here. And I want to highlight for the court that Peter's position on the applicable standard has evolved significantly, including as reflected in the reply brief. In the opening brief filed by Peter at page 7, Peter asserts that public policy favors arbitration and that any doubts concerning the scope of arbitration should be resolved in favor of arbitration, or any doubts concerning the scope of an arbitration agreement. In our response brief, Lauren cited to a recent U.S. Supreme Court case in Morgan v. Sundance, in which a unanimous U.S. Supreme Court clarified that any language in prior opinions that seemed to indicate that the scales would be tipped in favor of arbitration was a misreading of their precedent, and that arbitration agreements are to be treated like any other contract. There's no hand on the scale of favoring arbitration. So in the reply brief that Peter filed at page 4, Peter walked back his earlier assertion that there was that the doubts about scope of the arbitration agreement should be resolved in favor of arbitration, and initially says that arbitration agreements are not treated more favorably than any other contract at page 4. But by page 14 of the reply brief, Peter's back to citing an alleged or purported liberal federal policy favoring arbitration agreements. And so as a starting point, the court, we think for the same reasons as the U.S. Supreme Court in Morgan v. Sundance, should adopt an arbitration neutral position when evaluating the scope of the arbitration agreement at issue here, both under the Federal Arbitration Act and the North Carolina equivalent, which looks to federal case law as guidance. There are 4 independent bases on which Judge Earp held that there was no agreement to arbitrate in this case for this particular intrafamily dispute. In order for Peter to prevail on appeal, he must demonstrate that Judge Earp committed reversible error on all 4 of those holdings. The 4 holdings are that FINRA Rule 12-100 does not confer jurisdiction over FINRA for disputes between customers. Second, the arbitration agreement itself does not confer or require arbitration on disputes between essentially me and me in the contract language, meaning Lauren and Peter. It's only disputes between you and me, Schwab and Lauren, or Schwab and Peter. 3, a close reading of Peter's statement of claim shows that he's actually not claiming a right to the funds in the joint brokerage account. That claim originates from a college investment account and an alleged overfunding of that account that occurred no later than 2017. And that it's only that Peter has found assets in this brokerage account with Schwab to pursue that he is essentially piggybacking those two claims on top of each other. And 4, that the client agreement at issue has nothing to say about the ownership of assets, which is the question before the court on the merits between Lauren and Peter. On the first point of FINRA Rule 12-100, Peter failed to comply with Business Court Rule 7.2 by not raising his arguments related to FINRA Rule 12-313 in any of the 3 briefs that were before Judge Earp. She found that he'd waived that argument due to that noncompliance. And in the briefing before this court and in the oral argument from counsel, there's been no explanation or argument for why that noncompliance should be excused. And again, we hear argument related to FINRA Rule 12-313. On the issue of the contract terms and the definition of you and me, in 2 briefs, first filed with the trial court and then with this court, Peter has misquoted the key language of the customer agreement in a self-serving manner, essentially reading out entirely out of that agreement the terms you and me to achieve the desired result. After this was raised in Lauren's response brief, Peter filed a reply brief that did not acknowledge or explain this misquotation. And on the issue of the ownership of these assets and whether the client agreement says anything about that, I'd like the court to consider an alternative set of facts in which, rather than these funds having been transferred from a joint account to an individual account and Schwab having effectuated that transfer, if the funds just simply remained in the joint account and perhaps Lauren filed a declaratory judgment to ask a court to hold that those funds are hers and hers alone. In that scenario, Schwab would have engaged in none of the alleged misconduct, and which, by the way, my client is not bringing any claims against Schwab and does not allege misconduct as a basis of a cause of action against Schwab. But in that case, we would be having the same exact dispute resolved on the merits of who owns these assets. And in the alternative set of facts I presented to you, Schwab would have engaged in no alleged misconduct. But it is precisely that transfer and that transfer alone from the joint account to the individual account that Peter is relying on exclusively to hook this matter into FINRA arbitration. But as my counterexample demonstrates, whether these funds are in the joint account or frozen in an individual account makes no difference on the merits of the ownership issue. And on that issue, we expect the court will look at several factors, including whether Lauren indicated or expressed any intent to gift those assets to her father. And there's no evidence, we would contend, that would support such a contention. As I detailed earlier, this relationship is extremely estranged between the parties. And during the last several years, while these assets have been in the joint account, Lauren and Lauren alone has paid the capital gains taxes on the account. And so those issues will all be resolved later, but there is nothing in the client agreement that weighs on the court's determination on the merits of who owns these assets.
Can I ask you to address the argument that was made that this question of ownership is so interrelated with the issue that can go to arbitration, that there's this risk of inconsistent ultimate findings and that it's just not workable?
Well, I think Judge Earp crafted a carefully considered and worded decision in which she enjoined Peter from pursuing claims in the FINRA arbitration that would decide the question of ownership of the assets. And she reserved the right, because the res is in Charlotte, North Carolina, and as the court of jurisdiction in Charlotte, she reserved the right to determine ownership of the funds. And so I think as a practical matter, because Peter's enjoined from litigating that ownership issue in FINRA, what makes the most sense to my mind is that the issue of ownership would have to be decided first, and then Peter could proceed and continue in arbitration in Florida if he wished to do so. But he could only do so if he won on the merits of the ownership issue, because otherwise there's no harm or breach of any duty at all. Lastly, I'd like to close, and I've reserved 10 minutes for counsel for Schwab, by noting that we've asked the court to impose sanctions under Rule 34A2. And Lauren would contend that this appeal was filed for an improper purpose, to unnecessarily delay and needlessly increase the cost of this litigation. The hearing before the trial court on this motion to compel arbitration was a year ago last Thursday. During the time that this case has been pending and the assets have been restrained by Schwab, Lauren has been deprived access to the funds in her individual account, which total approximately $340,000 as of last check. I mentioned earlier she's a 29-year-old nurse practitioner. She's not, she just started her career a few years ago, is lacking in financial resources, and we had asked Peter as part of the stay in the trial court proceedings whether he would consent to an agreement with Schwab in which some of the assets would be released. There's $340,000 being restrained. His statement of claim in arbitration is he's entitled to $147,361. There's a significant excess being restrained by Schwab for posterity's sake, and Peter would not consent to release any of those assets to her. And the result has been that Lauren has been deprived of access to finances that she needs to be able to litigate her case, and she's been accruing legal fees on these procedural disputes.
I'm sorry to do this, but can I go back to the answer you gave me about the way in which these the ownership of the assets could be related to the arbitration? And your answer was, well, the court can decide ownership first, and then they can go ahead and arbitrate with Schwab. But as I understand the trial court's order, the business court denied a motion to stay the arbitration, right? So how does that factor into your answer?
I think Judge Earp and my friend from Schwab might be able to speak more on this issue since it relates more specifically to the arbitration involving Schwab. My client has not entered an appearance in the FINRA arbitration in Florida and takes the position that there's no jurisdiction over her until and unless a court in this state orders her to do so. But on the issue of a stay, I think Judge Earp distinguished between two things. One was whether she had jurisdiction or authority to order an arbitration forum in Florida to do anything, and the second, whether she had jurisdiction to order a party before her in the court, i.e. Peter, to refrain from doing something. And so I do read the order the same as you do, Justice Earls, where she did not expressly order anything of the FINRA arbitration in Florida, but she has enjoined Peter from pursuing any claim related to ownership of the assets in that FINRA arbitration.
Thank you.
If there are no further questions, I'd like to pass the baton to the attorney for Schwab.
Thank you, counsel.
Good morning. It's still morning. Good morning, Your Honors. May it please the court. My name is Neil Barretts, and I represent Charles Schwab. I find it interesting to be in this position because representing brokerage firms, I'm almost always on the side of compelling arbitration. That's the contract that's been negotiated and bargained for, and that's where we normally find ourselves seeking to compel parties to arbitration. I can't compel Lauren to agree to a fight with her father. Schwab has no ability to mitigate that or mediate that fight. If Lauren were submitted to the FINRA arbitration, then the rules of the game change. But in this scenario, as should be clear, the fight is over about these restricted or restrained assets that Judge Earls pointed out correctly, that she permitted Peter's arbitration claims to continue, but not with respect to the restricted assets, because that's a fight that Lauren has not agreed to, whether it be in Florida or in arbitration. She has not agreed to that, and therefore she's not consented. Could I compel her to arbitrate disputes with me arising out of my account agreement, meaning Schwab's account agreement? Yes, I can. There was a discussion by counsel here regarding this triangle. It's a two-legged triangle, Your Honors. It's a two-legged triangle in that Schwab has agreed with Peter to arbitrate disputes, and Schwab has agreed with Lauren to arbitrate disputes. But the missing leg is Peter and Lauren have not agreed to arbitrate a dispute over those assets. It's not going to be an inconsistent result, as argued, because when you break it down, if the trial court determines that the assets are 100% Lauren's, Peter's got a cause of action that he can pursue against Schwab, as that outcome may or may not have been negligent. Whereas if he prevails entirely and they're his assets, Lauren hasn't asserted a claim against Schwab. Case over. You can't get an inconsistent result. If Schwab was negligent as alleged with respect to restricting the account and then unrestricting it after the merger of TD Ameritrade with Schwab, then Schwab will have to answer to that claim.
I thought the potential inconsistent result, and correct me if I'm wrong here,
Please.
that your friend is concerned about is that the FINRA arbitration panel may say, we've got an arbitration we need to move forward with. We're moving forward with it. We can't decide the claims that belong here in arbitration without addressing a factual question that has a legal component, and that is who owns the funds. We're going to go ahead and do that. When that arbitration concludes, it'll be recorded as a judgment in Florida. And then the concern is when you come back here to the business court, what would happen if the business court is then trying to address the same issue? You have the funds, and you have a court judgment saying, this matter's already been decided, half of them belong to Mr. Marilley. So what?
Well, at that point, he's prevailed. He's gotten the half assets that he originally sought in the underlying arbitration. At that point, he's gotten the result he wanted. My dilemma.
But wouldn't
my dilemma is that Peter and Lauren have not agreed to have that fight.
What I'm saying is, but as with respect to Lauren,
yes,
Lauren would say, but I can't be bound by that. I need to go forward with this claim that's here in the interpleader action, right? Because she couldn't be bound by what the arbitration panel did. And
she would not be bound by any ruling. If the arbitration proceeds just with Peter against Schwab, that Lauren's not consented to, Lauren would not be subject to whatever ruling that arbitration panel determines.
Right. I think I did a bad job of explaining the concern that I was potentially seeing, which is that the only thing the business court can do is tell the parties, don't try to do this thing, but can't order the arbitration panel, if it properly has jurisdiction, not to resolve some legal question and factual issues before it. If those things all get decided, what will happen to Lauren is does something more need to be done to prevent the risk of these inconsistent verdicts, because Lauren would have a right to have a court in North Carolina also decide the ownership of the funds, and then you really could have two inconsistent verdicts about the same rest. So
there is certainly that argument, Your Honor, and there's certainly judicial economy arguments that would come into play here. However, I don't have the ability to compel Lauren to argue to fight that fight, so I have to go back to what my contract says.
Right. So your point is that seems to be your strongest argument. There are a lot of scenarios where there may be personal jurisdiction over one litigant in one place, personal jurisdiction of another. It's the same factual issue. There's just nothing that can be done, though. You can never bring those two to the same place and have them try. And we deal with that in all sorts of different ways, like offensive collateral estoppel and other things. But sometimes you just do have two inconsistent.
Sometimes you have inconsistent results, and the only other solution to that is consent. So you can submit to arbitration. She could voluntarily come forward and say, I'll fight that fight with my father in this forum, but interpleader is the appropriate result here, and that's why we believe the entire dispute, at least until ownership of the restricted assets is addressed, should be in the state court, in the business division. There's no other way to practically enforce this contract that I told you I seek to enforce all day long. And we litigate those in front of arbitrations. Counsel's also made arguments that he's not made in his underlying papers. There's an issue of waiver. He's not asserted direct claims against Lauren. Lauren has not agreed to fight that fight. The FINRA rules, one in particular that he mentions, Rule 12209, that talks about whether or not you can start a separate state court action during the pendency of a FINRA arbitration. That's a red herring, in that I can give you countless examples of where brokerage firms, in the context of being already in a FINRA arbitration, can go to court. There's discovery-related issues. There's a particular body of rules that go to injunctive relief. For example, Those rules say you can go to court to seek an injunctive relief, provided you also go to arbitration to hear the merits of the dispute. First, there has to be an entitlement, a determination as to whether or not there is a dispute that is subject to arbitration. That's this fight here. That's the discussion, whether or not the parties have agreed to submit this dispute. Can there be, as counsel points out, rules within FINRA that permit cross-claims? Yes. Joinder? Yes. All permissive, with parties who have submitted. That's the starting point. You have to submit to that process. By analogy, investment advisors, for example, are often sued in FINRA arbitration. They're not FINRA members. They can agree to be bound by those rules, but they don't have to. Therefore, they have to go somewhere else to have that fight. The somewhere else in this fight, quite honestly, is Lauren's counsel and Peter's counsel have argued, frankly, this is a dispute about ownership of assets. And unless and until that decision is made, you don't get to whether or not Schwab was, or you shouldn't get to whether or not Schwab was negligent. That can be arbitrated. I agree. Counsel is right that I have to, and then Judge Earp is right, I have to arbitrate those disputes. But to the extent those disputes concern the restricted assets, that's not subject to FINRA arbitration. They still may be negligent. Schwab may have breached a contract. But unless and until ownership is determined by the appropriate fact finder, in this case a jury of Lauren's peers, and presumably Peter's peers, that's where this belongs. I think that you heard enough of a recitation, and I've seen it in the papers and is acknowledged by counsel, that this is a family fight that goes back multi-generations to the grandfather who funded the account, as we understand it. Again, these are everything that I know about these underlying disputes, and this has been going on for years, as both counsel have acknowledged, is who's the source of the money? Where did it come from, and who's entitled to it? Schwab accommodated whatever the instructions of the parties were, and as this court knows, a joint account, either party has equal rights to that account, meaning Lauren could, in fact, if she wanted to, write a check to herself for 100 cents on the dollar or 5 cents on the dollar. She has that legal right. Schwab's account agreement, as referenced by counsel in other sections, give each party equal rights to those assets. Schwab's not going to stand in judgment and say, hi, Peter, Lauren just took all the money out. I just wanted to let you know. Likewise, the same would be true in reverse. It's a fight over who owns the money. And until that's determined, the issue of arbitrability of any dispute has to be stayed. If Judge Earp is determined ultimately to be wrong in terms of whether or not the fight over the restricted assets should have been stayed, that's a consequence we'll deal with, and we'll litigate it in the appropriate form. But for today's purpose, the contract says what it says. The terms, and there's a section right up at the front, in this court I'm sure we've seen, what the definitions of I and we and you. Just to summarize, Your Honors, Peter agreed to arbitrate his disputes with Schwab. Schwab agreed to arbitrate its disputes with him. That's one leg of the triangle. Obviously, the other leg is Lauren did the same. But Lauren did not agree to arbitrate her disputes with her father in front of a FINRA arbitration panel by jurisdiction submission, be it in Florida or in that forum. So unless and until there is a determination of ownership, which is the subject of a dispute that's not been submitted to FINRA, there's nothing to proceed with. I don't want to, as my learned counsel told me, the Gettysburg Address lasted 2 minutes, so I don't want to overstay my time. If the court has any questions about our position, I'm happy to answer.
Thank you, counsel. Rebuttal?
Your Honor, briefly, my friend said that Lauren did not seek this fight with her father, but she did move the funds from the joint account to the individual account and take pains to keep him from knowing that. So she initiated that. Counsel stated she wants her right to a jury trial. She specifically waived it in the arbitration provision, says you waived your jury trial right. It's not an improper purpose for my client to seek to invoke his substantial right to arbitrate, particularly under the circumstances here where Lauren is the one who moved the money from a joint account to the individual account. Lauren did actually allege misconduct against Schwab. It is true that she didn't bring any claims. However, record 3738, she said 3 things that Schwab did wrong, all 3 of which could have supported a claim. Schwab had no legal authority to restrict the account. The no trade restrictions contravened her rights, and the Schwab employee who did it acted outside of his authority when he did it. So those would all be 3 grounds to support an arbitration claim, and she did, in fact, make those allegations. So it's not true that she's not alleged wrongdoing by Schwab at all. It seems to be that Schwab concedes there's joinder. I think I heard counsel say that, but said that missing leg has to be consented to. It can't just be assumed. So we know it's not just that there's only going to be two parties. There could be multiple parties, and those multiple parties could address one controversy all at the same time. Neither of my friends addressed on its head this question of inconsistent verdicts and outcomes. Both of them I heard say the same thing, to say something that's not in the order itself, which is that the court could determine ownership first as a preliminary matter, as a threshold matter, and then, and only then, could the arbitration panel determine wrongdoing by Schwab. But the order doesn't say that. The order allows arbitration over negligence and breach of contract to proceed, reserving the right to make a determination as to ownership. So while I understand the argument that it might have made sense for there to do it that way, that's not what the order says. And in fact, I do not believe that the business court would have the authority to have done that anyway, to say, well, the right to arbitrate is going to be contingent on whether we make this finding first. I did not hear either counsel address that. The fact of the matter is that both the arbitration panel and the court are going to address ownership. The court has said it's going to do so, and the arbitration panel has to do it to make a determination as to whether there's wrongdoing in the first place. Again, it's an essential element to both the negligence and breach of contract claim. So whether or not the arbitration panel explicitly states that it's addressed that or not, doesn't really matter. It has to do so.
Don't arbitrations often operate under sort of the same rules that courts do? So the friends that are representing Schwab could ask the panel, stay this part of the case until we get a ruling from the business court on the ownership, because we're pursued from even trying to argue that in front of you. Then you don't have to worry about the inconsistency of the judgments anymore.
Well, that's really already been ruled upon, though, Your Honor. I mean, they already asked for a stay of the arbitration, and the trial court said no, said allowed it to go forward. So
But wasn't that for a different reason, which is a question of whether there would be the power to stay that portion of it? But couldn't the arbitration panel say, we think under our rules, we think it makes sense to hold this in abeyance, to stay it until somebody, is that something that they could do?
I don't think so, but I mean but that has not happened. So whether or not that idea makes any sense, it's not in the record. So, and it isn't supported by a judge or its order. So if the arbitration panel did that, of course we'd be pointing at the order that says no, this arbitration is not stayed at all. These issues, this issue of negligence and breach of contract, are ripe to be heard by the panel, and the panel has to implicitly consider it. So I understand the argument, but that argument has not been made. So we still left with those practical considerations, and those practical considerations underpin the policy of allowing arbitration to be as broadly interpreted as it should be. One thing that counsel pointed out about this, whether or not what deference the court should give if there's doubts about scope. Well, the case law is pretty clear that if there's doubts about scope, they should be resolved in favor of arbitrability. The case that counsel points out to, Morgan Sundance, addressed waiver, not specifically scope. So I don't think it really matters because the facts support arbitration anyway, but the general rule is if the parties have agreed to arbitration, that is what their form is because they agree to it. On the issue of my predecessor waiving the right to argue that the FINRA rules are incorporated into the arbitration provision and thus can't argue it now. Counsel says we haven't addressed it. It doesn't need to be addressed because this consideration of conclusions of law is done de novo. So it was not necessary to make every single argument. We can certainly cite other cases and other authorities at the appellate level that aren't cited at the trial court level. That's what de novo is. Also, the rule cited by counsel, Rule 7.2, the business court rules, simply says a party should therefore brief each issue and argument. It doesn't say that they must. So the missing part of the brief is the reference to these rules that are part of the arbitration agreement itself. So that should not stop this court from considering whether or not the rules allow joinder, which I think counsel is conceding, and whether or not though that joinder, the ability to join other parties, makes the reading, the most logical reading of the arbitration provision to be that there can be eye-to-eye arbitrations as well as just I to you, all joined in the same proceeding to avoid the inconsistent outcomes that are very likely to happen in this case if the entirety of the matter is not arbitrated. Subject to your questions, thank you for your time and patience.
Thank you, counsel. Thank you. No, sorry, the argument's over.